Ask that you all rise for the pledge of allegiance, followed by a moment of silence, as you are able to rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Board members, please turn on your microphone.
Cassie, could we have roll call, please?
Sure. Trustee Kreiser. Here. Trustee Grabowski.
Here.
Trustee Gergen. Here. Trustee Rhodey.
Here.
Trustee Belt. Here. Trustee Krasovich. Here. President Knutson.
Here. Okay, for tonight's new meeting, second thing we have this evening is under new business, hearing on an appeal of the 2023 Fire EMS Protection fee filed by Cecilia Senior Homes LLC regarding real property located at 1061 Cecilia Drive and having tax ID number PWV 0902-996-008 and possible action thereon. So Mark, I will look for your guidance to start us.
Just some background information for everyone present. So the village has this fire/EMS fee ordinance. It's found in Chapter 93 of the Village Code. And one of the elements in that ordinance is a provision that allows for appeals of determinations that have been made regarding assessments under that ordinance. The first mechanism of appeal is dealing with arithmetic errors that might have been made in terms of the dollars that were assessed and the number of units that were assessed. The second is dealing with issues that involve the categorization of, primarily the categorization of a particular property as fitting within a certain number of units, and whether that determination, that definitional determination is appropriate. So we have on the agenda tonight two applications, one for 1061 Cecilia Drive and the other for 1105 Hawthorne Place. And I understand there's counsel here for both parties. We'll take the Cecilia Drive location first. Each party will be entitled to make a presentation to the village board regarding why they believe the appeal should be granted and why there should be a change made regarding the assessment that was rendered and whether there should be any kind of a refund of that assessment based upon whatever determination would be made. And so basically, if under our ordinance, section 93.105, it indicates that the board shall determine whether the number of ESEs, which are the equivalent units that are assessed for each property, whether that is assigned in a fair and reasonable manner in accordance with the terms of the ordinance. And then in the event the appeal was granted, whether or not a refund is due the appellant and the amount of the refund. So that's the pertinent language regarding what you're going to be hearing this evening. So we'll let each side make their presentation. Each one of these will be held individually. And then we'll have a presentation made by representatives of the village, the administrator, and then also the consultant that worked on the preparation of the information that was used in approving the ordinance in response to whatever they may hear this evening, and then the board will be able to make a determination. A motion would be made either to uphold the assessment or to modify it, and then the grounds that would support either one of those actions. And if the refund is appropriate, what you believe that should include, that would be also part of that motion. And then, based upon whatever motion is made here this evening, then there will be a written determination that will be prepared subsequent to this meeting that you will review and make a determination as to whether it is consistent with your determination on this matter, and then that will fulfill the requirements of the ordinance. So, are there any questions from the members of the board regarding anything I've just said? Okay, so then, Ms. Summers, I believe you're going to make a presentation regarding 1061 Cecilia Drive. Yes, please go to the podium and use the microphone so we can make sure that your comments are recorded. Thank you.
Do I need to get it like good, or do I need to move the microphone closer?
Yeah, a little bit of, that's good.
Okay. I'm also a
It's-
little bit on the
It's
diminutive
quirky,
side, so-
right, that's good. And then if you could just identify yourself for the record, please.
Is that good, or do you, can you
Yes,
hear
I
me
think it'll-
okay? Okay,
I think that works. Go ahead.
perfect. My name is Christina Summers. I am with Reinhardt Berner Van Duren, and I'm here today on behalf of Cecilia Senior Homes. We appreciate the opportunity to appear before the village board today, and we appreciate the village board's efforts regarding providing funding to make available fire and EMS services. We also appreciate the opportunity to have continued discussions with the village. If the village board does believe that it would be helpful to have further discussions to achieve potential resolution, I believe my client would be amenable to those. But as mentioned, we are here today following the procedure in the village ordinance with respect to a hearing. So let's talk a little bit about the village ordinance. And I know we're going to talk about the reasonableness, the different categories, but I want to take a step back as well and talk about kind of the authority and the background relating to the fire and EMS fees and the methodology for applying them here today. So we're all familiar with the ordinance 2023-22, which created Chapter 93 of the Village Code, which provides for the fees to authorize the imposition of the funding for the fire and EMS charges. We're going to talk a little bit about, I'm a lawyer, so we're going to talk a little bit about the statutes, some of them that are applied. We're going to talk a little bit about some of the cases as well, just to give you the appropriate background, if again, continued discussions would be amenable to resolution here. I didn't bring the cases, I didn't bring the statutes. I'm trying to cut down on killing trees, but if anyone would like additional information before a decision is made and a written determination is issued, I would be more than happy to provide that information. So as we talked about, we have the village ordinance that provides for the emergency service equivalent, or ESE. How that's defined in the code is the base amount used to calculate the amount of fees charged to each single family duplex property, regardless of the size or value. So as the Baker Tilly report prepared, it came up with these different classifications and categories. We have certain residential properties that are, the categories are single family duplex. We also have multifamily. And then we have senior living and care home. Notably, when the original Baker Tilly report came out, we only had one category of senior living, but that since was modified to senior living and care home. So the single family and the duplex, that is assessed a rate of 1.0 ESCs per unit, or $241 per unit. The multifamily, again, that's the same. You have your 1.0 ESCs per unit. And then on the other end of the spectrum, nearly 5 times that initial rate, we have the ESCs assessed to senior living and care home, which are assessed 4.75 ESCs per unit. Just briefly, we're going to discuss the definitions because that gets into the relevance of what is the right category. Should there be different categories? Should they be assessed in a different manner? I think that is relevant for the board's consideration, certainly. So senior living is defined to include residential care facilities, and senior living residential developments, which are marketed and or limited to residents 55 years of age or older. That's a really broad category. We tend to think of that as independent living. I'm almost 55, so it could be me, or it could be someone who's 30, 40 years older than me as well. That's a very broad category that could have very different usage of fire and EMS charges. Care home includes residential board and care or 24-hour care nursing homes where care is provided for 4 or more persons. So that might include our property, which is a residential care apartment complex. You might have heard the term acronym RCAC. It might also include CBRFs or community-based residential facilities. And again, based on the definition, it might include 24-hour care nursing homes. Again, a really broad category that could include vastly different actual usage of fire and EMS charges. So those are your 4 residential category options. Then we have 3 non-residential: commercial, industrial, and institutional. Another interesting note for the board, you may be aware of this, but I just don't want to make any assumptions. That's why I wanted to kind of take you through this. Originally, in the Baker-Tilly report, commercial and industrial were grouped together. Then it was reviewed further. Those were broken out and assessed different ESCs. So again, that's an option, is to look at those. We only have ESCs in the residential units that are charged 1 ESC, and then others that are charged 4.75. So you could always have somewhere in between. As mentioned, we're here under Chapter 93 of the Village Code. We done all the necessary steps to get to where we are here today. We filed the petition. The village administrator has reviewed the petition and made a determination that there is no error in the calculation. We're not alleging that there is an error in the calculation, just to be clear. The Village Code allows for the ability to appeal to the Public Works and Safety Committee. For expediency, we waived that right, and we're here in front of the Village Board to kind of speed up that process. So as mentioned, the Village Board shall hear and decide appeals made on the basis other than an alleged error in the determination of residential ESC or building square footage ESC determination. The board shall determine whether the number of ESCs assigned is fair and reasonable, and in the event the appeal is granted, whether or not a refund is due the appellant and the amount of the refund. So again, that's the discretion the village board has to determine whether there's a refund and the amount. The village administrator, I think we'll hear from the administrator, will provide support, evidence in support of how the original assessment was made. And as mentioned, ultimately, the board shall render a written decision based upon the evidence presented. Again, for that purpose, if there's something else that you guys think, based on the presentations or otherwise, that would be important for your determination, please ask me the questions. We'd appreciate the opportunity to provide that response and additional information so you have an opportunity to make a full and fair determination. As mentioned, I'm here on behalf of Cecilia Senior Homes. We are an RCAC, residential care apartment complex, so within the categories, we are a care home. The 2023 tax bill had net property tax of $73,030.23. There was a fire inspection charge of $768.56, and then fire EMS charges of $65,311, which nearly doubled the property tax bill to bring us to the total bill of $139,109.79. So again, a very significant increase in the overall property tax bill for these charges. Just a little bit of information about the authority of the village and generally to give some guidance about the statutory and legal landscape. So villages, like cities and towns, but with some differences, are created by statute and Wisconsin law. The powers are similarly prescribed and limited by Wisconsin law. So one of the statutes that was cited in the ordinance is under Chapter 66, which is General Municipality Law. So 66.0627 provides authority, but limited authority, for the imposition of a special charge against real property for current services rendered by allocating all or part of the cost of the service to the property served. The statute gives additional examples of items, services for which special charges may be imposed, including snow and ice removal, weed elimination, street sprinkling. Yes, that is actually a thing, street sprinkling, oil and tarring, repair of sidewalks or curb and gutter, garbage and refuse disposal, recycling, stormwater management, and various other services. Notably, When you look at that list, and then you look at our fire and EMS charges here, these charges are unlike any of the services identified that serve the real property. So there is a significant difference there. Moreover, the charge must be for current services. That's actual use, not just the possibility of use. So here, in addition, where the charges are based on property category, again, the care home or the senior living versus the single family, duplex, or multifamily, this difference disproportionately and unreasonably assesses the fire and EMS fees against the property. A couple other concerns of note: when you look at the data identified in the report that leads to the calculation of the ESCs, that data was from 2020 through 2022. That's a fairly limited time period. We only have 3 years, during which years the pandemic, we were faced with this global pandemic. That, I think we can all take notice, significantly affected many people, including older adults. One would believe that data is available for a longer time period where you could look at that data, make sure the actual numbers are stabilized and representative of a period for more than just a 3-year period during which we have the pandemic. Because that's what we want to do. We're looking at the data, we want to make sure it is relevant, it shows data for a period that's stabilized and isn't adversely impacted by something such as a global pandemic. In fact, based on information and belief, if you look at the numbers before 2020, those would reflect lower usage of fire and EMS services than that 3-year period that was used to determine the ESCs. And as mentioned, the care home category, similar to the senior living category, is very broad, overly broad, and as such doesn't reasonably allocate based on the different actual uses for those residing in such properties. A couple of other statutory notes for the board's consideration. Fire EMS charges, when you look at the various statutes, we talked about Chapter 66, which is that general municipality law. There are also specific chapters that relate to towns in Chapter 60, villages, such as the village of Pewaukee in Chapter 61, and cities in Chapter 62. So focusing for the moment on the chapter for villages, and specifically 61.65. So that particular statute, interestingly enough, allows for different ways to provide for fire and police protection. So there are 3 options under 61.65. One option is for a village to create its own fire department. I believe the village of Pewaukee had that for years prior to 1995 through a volunteer fire department. Another option is to create a joint fire department with a city or town or with another village. Again, I think the village explored and used that option from the years 1995 to 2004. The third option is contracting for fire protection services with a city or town or with another village. And I believe that's where we are here and have been since approximately 2004, so the last 20 years or so. What is notable about that provision is it specifically says a village that contracts for fire protection services shall pay the full cost of services provided. So that is significant and should be noted. Now, in the ordinance, the village references a couple of cases. The town of Ford versus Clark County was one of those cases. As I mentioned, there are different statutory provisions and chapters relating to towns versus villages versus cities. So that case, the town of Ford case, involved a town. And so in that case, the court looked to the statute relating to towns, Chapter 60, and specifically 60.55. Now that statute provides that a town board shall provide for fire protection for the town, similar to 61.65, which is the provision involving villages. But 60.55 goes on to address funding, authorizing a town to charge property owners a fee for the cost of fire protection provided to their property according to a written schedule. Or it also authorizes the town to levy taxes on the entire town or on property served by a particular source of fire protection. Notably, the court declined to address the town's argument under Chapter 66, and specifically that provision we talked about, 66.0627. There's another case, we won't go over too many, just 2 more. There's another case, Town of Janesville versus Rock County, a Court of Appeals case from 1989. It is notably consistent with the Town of Ford case. It also looks to Section 60.55 as permission for imposing the per call fee that was provided for in that particular municipality. But more importantly, perhaps, it looked to that version of 66. There was a change in the statutory references, but the current version is that found in 66.0627. And the court recognized that the statute only allows charges for services actually provided and not for services that may be available but not utilized. So that's a significant difference there. The court also found that the town's method of computing the charge only went to the cost of the availability of the service and not the cost of performing it. So again, availability versus performing. It did allow for the per charge call. It did not allow for fees that would provide for the service versus the services actually provided and used. So it recognized that 66.0627 would only allow for the cost of fire services rendered on a per call basis, contrasting to what we have here. Charging on an ESC basis, emergency service equivalent, is not a charge calculated on a per call basis. It's not for services actually provided, it's for services that are made available. And it's based on an average, and a limited year average that's then calculated and apportioned on overly broad residential categories. There's some other cases and statutory provisions referred to in the ordinance. Some are not applicable, such as there's 61.34 that provides general powers of the village board, but it also provides except as otherwise provided by law. So that directs us back, and we need to look at 61.65 and what it allows or what it doesn't allow. There's a case cited in the ordinance, Hack versus City of Mineral Point. It's a 1930 case, so coming on 100 years old. Some of the differences, it involved a city, not a village, and we discussed how that is relevant for our purposes here today. It also, given the time period, was an ordinance prohibiting transportation, possession, sale, and manufacture of intoxicating liquors. That's now permitted today and not, similar to what we have here. And a subsequent case, State ex rel. Keefe, a 1947 case, found that the doctrine in the State versus Hack case cannot be maintained. So when we look at what we have here today, and you look at what the charges are, we obviously have to look at what they're for and not necessarily what it's called. When we do that, we see that really this is more akin to a property tax. A tax is any payment enacted by the state or its municipal subdivisions as a contribution toward the cost of maintaining governmental functions where the special benefits derived from their performance is merged in the general benefit. Here, fire protection and EMS services are governmental functions, and they are of general village-wide benefit. So when we look at everything, when we look at the statutes, when we look at the case list, what is concerning here is the lack of authority to be able to impose the fire and EMS charges in the form that they currently are provided. They're disproportionate. We only have the 2 categories of residential properties, essentially 1.0 ESCs, and then all the way at the other end of the spectrum are 4.75. As such, they are excessive and not reasonably apportioned. And because of all of that, there are constitutional concerns as well. Arguably, this violates Article 8, Section 1 of the Constitution. More fondly, we refer to that as the Uniformity Clause. So ultimately, when you look at everything, what we're here asking the village board for today is to cancel our EMS and fire fees of $65,311, or we really think that that's the appropriate result. In the alternative, we believe that a more reasonable methodology of assessing the property would be to put it in the same category as the single-family, duplex, and multifamily properties and be charged at most 1.0 ESCs per unit. So that would be the alternative remedy that we would be seeking. Happy to take any questions from the board.
Does anyone have a question for council at this point?
Not at this time, I guess.
All right, thank you. Does that conclude your presentation?
It does.
All right,
Yep.
thank you.
Again, if anything else comes up, or any comments are made by the administrator or outside consultant.
I will allow for limited rebuttal. We don't want to be rehashing something we've already talked about. So at this point then, the board would hear from the administrator and the consultant regarding the fee that was assessed regarding this property. And any response you want to make to what was discussed by council. Please.
Scott Gussie, Village Administrator. When the appeal was submitted by the petitioner, per the code, took a look at the property categorization and the number of VSEs, which is outlined as the methodology for reviewing appeals. The property was categorized as a care home in 2000. It was issued a conditional use grant for the purpose of constructing and operating a senior housing development consisting of 80 units of assisted living and 58 units of congregate care apartments. In 2004, 2005, it was granted an conditional use grant amendment for 57 congregate care senior apartments to operate as senior condominiums. Minimum age of condominium residents shall be 55 in accordance with federal housing law. That's from the conditional use grant. So the fees were calculated with the ESCs based on the use of care home. There are 57 units, 4.75 ESCs comes to the total of the 271 ESCs, and that was the basis on which the fee was assessed. So staff believes that we follow the methodology outlined in the ordinance for assessing the fee.
Any questions? Guess not.
It's up to you to decide what you want to present to the board at this point, so.
Just briefly to address some of the questions about the, I'm sorry.
Please.
Matt Stark from Baker Tilly. Thank you for having me tonight. Briefly addressing the questions on the categorization of the different properties. In the course of my analysis of the incident data, there were a number of addresses that jumped out in those incident reports as having multiple calls to them. And having identified where we had properties that had multiple calls, I tried to figure out what was going on with those properties, and essentially found that we had care homes and we had 55 and up communities that were driving a disproportionate number of calls. I was not trying to draw very fine distinctions with fine-tooth comb. It was just looking at the pattern of calls. For most residential types, they had maybe a third of a call over the course of that 3-year period. 1 in 3 would have something, whereas we had some of these that had 6 and 12 and 15, and some of them had upwards of 100 calls. So to the extent that we were categorizing calls, it was really just based on the patterns of usage that we saw. I don't really have anything else to address unless there are questions that you have for me now.
Can you speak to the issue of how you picked the 3-year window then to make that, because that was raised as a question about whether the data set should have been larger?
Honestly, we were looking at what our most recent data was. I do understand that there was, COVID was a kind of an interesting factor that, messed things up a little bit. But by the same token, if we went back 10 years, we'd be missing more recent developments. And so looking back on a 3-year look back just seemed like the most reasonable balance for getting a reasonable sample of calls to look at without going back too deep into the past.
Anything further? Any questions for Mr. Stark?
Heather, did you have a?
My question was what Mark asked.
Okay.
Mr. Grabowski, you have a question?
That one was one of them, as well as, do you have the specific call volumes for the properties in question this evening?
I'd have to fire up my machine and see if I could pull up the original incident reports that I was using for my source data. But I could make that happen.
I think.
Why don't you do that, please, Mr. Stark? And then while you're doing that, I'm sorry, Heather, did you have something?
Yeah, I was just saying that I'd like to see
All right.
that.
And then while you're doing that, Ms. Summers, if you have something you want to follow up on by way of a comment, you can do that at this point then. Unless, Mr. Stark, you have anything else?
Nope.
Okay, all right.
Can I ask, sorry, I have one question.
Sure.
Can I get clarification I'm sorry, I got confused over what the property is, 57 units, Cecilia Place. Is that what I'm understanding, total 57 units?
I
Scott?
deferred to
Okay.
Scott. Yeah.
And they're all just 55 and older, or there is assisted living or care at them?
Yeah, the current this amended CU was for minimum age of condominium residents shall be 55. So it's at care home, 55 and over. The senior, it'd be the same ESC equivalent as the senior care home or senior housing.
Right, but, and I don't know, maybe, I don't know if this question's appropriate now or if it's more appropriate for Shannon or Sharon, sorry.
Kristen.
Huh?
Go ahead.
Yes, Summers. I'm sorry. I don't know. I'm sorry. I got the S stuck in my head apparently. So is there any care provided at the facility? Like, there's.
Tell you what, I'm not
nurse? Like, I don't know
sure,
if this is an
maybe that's a
appropriate
question
right
for
now.
her
So that's,
too.
okay.
So when she gets up
I'm
to
trying to
make
gauge
her-
what understanding of what the property is
Okay.
actually is what I'm trying to go for.
All right, thank you, Mr. Stark.
And-
Ms. Summers, I'm sorry.
And could you also address about whether it's condos or apartments?
So Ms. Summers, it might be helpful then if you could categorize or describe your client's use of the property and what the resident demographic looks like.
Yeah, and my client is here today, so we may need some additional input on the specifics, or we can certainly, I appreciate the board's questions because I think some of that information may help determine should there be additional or different categories. Maybe it shouldn't be so extreme from 1.0 to 4.75. So, and to the extent we don't have all that detail here today, I would ask for the opportunity to provide it, and maybe a resolution can be reached with somewhere, some modification. Just before I lose my train of thought, initial in responding to Mr. Stark or following up on his comments, which I appreciate, it sounds like he's able to pull up the call volume. We would also ask for that information be provided to us as well. Not sure how voluminous and if it could be printed or emailed or otherwise transmitted, but I just would make that request. It also sounds like in addition to the 3-year set, that additional data might be available beyond that. We talked about, I think he made some comment as to if we went back 10 years, there is more data available. I think he commented there might be missing more recent events. I'm not sure what that goes to, but would appreciate any clarification. As to trustee
Bells, you can say it wrong, that's fine. That's fair.
As to the trustees'
No, you're even.
question,
Go ahead.
I can get closer and pull out my glasses. As to the specific questions by the board, again, it went to a little bit the question of kind of the use of the property. The property is categorized as a residential care apartment complex, so there is care provided as well as, I believe, a limited amount of available services. Now, again, that care home category has some very distinct or very broad potential types of properties, because it goes from anything that provides that residential care and boarding to your 24/7 nursing home. So that's very different. I think that is in fact overly broad. So I think those, I believe they are essentially apartment units, not condos, correct? I'm getting affirmation from my client. We want to make sure we get it all right here, and again, we can provide additional detail where certain limited available services are provided or available. Okay.
Sorry, can we get an idea?
Wait a minute,
Ready?
one at a time.
Go
Oh,
ahead.
So Mr.
sorry.
Grabowski had his hand up first. Go ahead.
Sorry.
I mean, it's pretty easy to determine with the owner being here. Can you give the exact breakdown of how many beds per continuum of care? So we're talking everything from apartments to independent living, to assisted living, to nursing or skilled nursing, to memory care. I mean, that should be pretty easy for a nursing home to provide.
Well, I can tell you exactly what.
Well, wait a minute. Why don't you come to the microphone, first of all? Identify yourself and what your capacity is with the appellant here, and then go ahead and answer the question.
My name is Michael Poston. I'm the administrator at Cecilia Place Assisted Living.
Thank you, sir.
So, 57 units. I would say 95% are assisted. The remaining are independent. That is it.
So no skilled
So,
nursing,
so no skill,
no memory care.
no memory care. So there's only, you know, round numbers, 90% assisted, 10% independent. So that continuum you were mentioning would only be independent to assisted. Past that, it's a different type of building.
Do you provide any ADLs?
Yes,
And ADLs, for the record, are assistance with the activities of daily living, correct?
Correct.
Yes.
dressing, bathing, medication.
Understood. Does anyone else have any questions for the administrator?
I have a question and a comment, Mark.
Well,
Stop me
let's
if I...
save the comment for the deliberations, so just ask, we're in fact-finding mode right now.
Okay, I'll wait then, if you want me to.
Well, you're free to ask any questions, but if we're talking about your opinion based upon what you've heard so far, let's wait till.
No,
deliberates on that.
it has to do with having been on the board for these many years and dealing with the fire and EMS and the cost and
Okay, that, we're
calls.
not going there at this point.
the
then.
calls that were made.
We're talking about this particular property, and we're hearing from this particular appellant, and we're hearing from the administrator in response to how they were assessed.
This has-
Your own opinions or data about what the history of this property are, you're not providing, you're in the
Okay.
role of reviewing what's taking place, not providing evidence. Does that make
Okay.
sense?
Yes.
All right, thank you. Anything else, sir?
No.
All right, Ms. Summers? I'm sorry, Jim, go ahead.
Do you have a question?
I was just gonna actually ask, Mr. Stark, are you looking at as well, like what's been current since the data was first analyzed, so the 2020 to 2023? Can you provide from the end of your data through like year-to-date, essentially, to see if that trend continued? And then comparably to the balance of the village? And that might be more, yeah, I don't know how to.
Sure. The data that I was given for my analysis was 2020 to 2022, the full calendar years. I have not seen the data for 2023 or for 2024 thus far. But, you know, I was doing my analysis approximately a year ago, so that.
Is it possible to get that information?
So let me just stop you
Ask
there.
for it.
All right, so just for the record, what we're dealing with here this evening is an appeal of the ordinance as it exists and its application to this particular party. Now, council has raised the issue about whether, in fact, what was used in the ordinance for the time period to determine the ESEs was an appropriate length or not. That goes to whether the ordinance in and of itself is appropriate or valid, or whether it's based on erroneous assumptions. We're not going there this evening. We're going on applying the ordinance as it currently exists and looking at how it applies to this particular property. Whether, in fact, there should be changes made to that ordinance is a discussion for another day, and whether the ordinance is valid is also a question for another day. So let's stay focused on what we have right now, which is the 3-year window. Mr. Grabowski.
Can you speak to when a resident would transfer out of your facility and what the specific criteria is from Cecilia Place from when they are no longer fit for assisted living and need skilled nursing?
So the majority of residents that would reside by us really do not leave until that memory starts to advance, the lapse of memory starts to advance. We're not a locked unit. It cannot be locked in as in a memory unit. So when they start to show signs of eloping, wandering, that's when we begin that discussion of a memory unit. Or for a skilled type facility, if you know what a Hoyer lift is, something along those lines, that is way past our capabilities. So that would be another step up to a skilled facility.
So outside of that, you allow age in place for the full?
Age in place, hospice.
Okay, and you don't provide any lifting services there? So any fall, anything would require fire EMS response to?
Depends on the fall, and it depends on the person. Okay. So yes, we do have staff there 24/7 that can assist with all lifts, but there are some lifts, broken hip, broken knee, where EMS is needed.
Okay, thank you.
Sure.
Any questions from the board with regard to the comments made by the administrator then? Okay, thank you, sir. You can sit down.
Thank you.
And Ms. Summers, did you have anything else that you wanted to add by way of a comment before we hear from Mr. Stark with whatever he might have found? Okay, Mr. Stark, why don't you go ahead, and I think the question that was posed to you related to the call volume that you reviewed for purposes of this particular property, and if you could relate that to us, that would be helpful.
Certainly. So looking at the incident report, there were 87 calls for service to 1061 Cecilia, and that was out of a total of about, I believe, 2,300, 2,330 that we were looking at for this universe of calls. If you refer back to my memo from last year, we were pulling out some calls that had to do with calls in the right-of-way that couldn't be assigned to a particular address. So yeah, 87 for this address.
I'm sorry, the total amount of calls were how many?
2,330, I believe.
And that was for the full 3-year span?
Yeah, hang on, I'll pull up, I'll double check which list I'm looking at. Oh, no, this was the full list. This was 2,858. Apologies for my mistake. 2,858 was the total on this one.
All right, thank you, Mr. Stark.
Certainly.
Anything else, Ms. Summers, that you'd like to add? All right, so we'll close then the receipt of information regarding this hearing, and at this point, we'd be looking for any comments the board would have and whether anyone is in a position to make a motion. Now, a comment was made that that it's possible that you may be looking for additional information that you'd like to receive before you make that determination. If that is in fact the case, you could also identify specifically what you would still like to receive, and then would adjourn this any determination on this until after you've received whatever that information might be. So the options at this point, again, would be to ask for additional information, in which case we would adjourn this hearing until that's received. Second, if you wanted to, if you believe that the record supports the determination that was made in terms of the assessment of this property, you can make a motion to that effect. or if you believe that that in fact the assessment that was made for this property is not accurate in light of the information that was received, is not fair and reasonable, then you can make a motion to that effect. And whether in fact you believe in that situation, whether any kind of an adjustment to the fee is appropriate. So with that, I will open it up to the board.
I myself, starting out, I guess, would need more information. There's some questions I have that I'd like to find out.
Okay, and if specifically then, what questions or what information would you like to receive before you make a
Here,
determination?
I understand it's for the past 3 years, but he did open it up and say it's been the past 10 years. When they looked at the data, were they looking at the number of calls based on false alarms, transports, actual fire, assisted lifts? The police, well, of course, the police department is totally separate, so, but I didn't hear any of that information.
Mr. Stark, are you able to respond to those questions that Mr. Knutson raised?
Sure.
All right, well, come back to the podium then, please.
Can I?
Well, let's deal with one issue at a time. So let him answer this, and then.
In regard to this.
Okay. You can follow up after,
Okay.
then we hear from him, all right?
All right.
So, Mr.
In regards
Knudsen,
to
go ahead.
the calls that were included or excluded, I'll refer back to my report from last year. We spelled that out in there. Of the 2,585 calls for service that we looked at that were not involving things in the right of way, we had 72 distinct incident codes in there. So we had grouped those into either fire calls, EMS calls, or, well, just miscellaneous calls. To your point, the miscellaneous group was things like false alarms, no incident there, you know, if it was a response was made and there was nothing going on there. So things of that nature, they were excluded from our analysis. We were looking strictly at fire calls and EMS calls when we were doing this analysis. So that was part of my confusion earlier of the number of calls, because overall we had 2,585, but we whittled that down to 2,211 calls for emergency medical services and 374 that were fire.
Okay, so basically, if the fire department got there and there was nothing there, they just left. And that was not counted.
Right, those were categorized as being outside of the scope of what we were looking for. Just because it would be impossible for us to nail down if somebody was making a prank call to somebody's address, we weren't going to assign that cost to that address, since they
But you couldn't
make the call.
verify if it was a prank call or not.
Prank calls was one of the categories we looked at where they could, you know, they just assumed it was a prank call or asserted that it was. So yeah, I'd have to look. There were, well, I don't have the actual list of calls in here, but there was 72 different codes that we looked at for incident responses, and we pulled out the codes that did not have to do with actual fire and EMS services.
So accidental dialing, that sort of thing, would all be in that cluster.
Right.
Mm-hmm.
So basically anything where there wasn't a full response, we wanted to pull out the false alarms, essentially.
So, Mr. Knudsen, any other questions you have for Mr. Stark then? You were seeing for more information you were looking for?
Well, I can't make them because we're dealing with this particular subject. I'm just remembering the old way it was done, so.
Okay, we're looking at this ordinance
Right,
being
so I
applied to
can't-
this situation, and that's all we're looking at.
Right.
I think Bob has a question.
All right, go ahead, Bob.
Okay, Matt, in regard to the comments for the data, the last the 3 years that you were citing, I think the danger you run into when you're getting into detail, you're going to suffer analysis paralysis. Okay, what's going to be important, if we can take a 3-year period of time prior to 2020 or COVID and compare it to the COVID, make sure that the comparisons are equal as far as the type of calls we're doing and see what the ratio is. And if it is truly increasing during the COVID period for the 55 over, more so than the general population, I think that aids in us making a decision. But I think if you go into too much detail, it's not going to help you. What you just need to make sure is the prior 3-year period is the same type of calls as the COVID period that we used, and make your determinations off of those ratios that you're looking at.
And that is consistent with the recommendations from our memo, which was to revisit your trends periodically to see if things were changing enough that it would warrant rebalancing things.
So correct me if I'm wrong. Occasionally, the police department will do lift assist too, right?
Yes, if there's a call and they're there first before EMS arrives and they feel comfortable, they can do a lift assist. Otherwise, they'll wait for EMS to arrive. It's a judgment call in the field.
And do we track any of that information?
I'd have to check with the department.
Okay.
I'm sure, presumably there's a log if there's a dispatch. It's just a matter of pulling that information together.
Okay, go ahead. Chris, I think you were first.
I do, yeah, have a quick question or a quick comment. I'm inclined to agree that the category that includes 55-plus apartments deserves a second look to determine if it is appropriate to create a new category based on facilities of this sort. I'm almost 55 too. It's not just you. So I promise you that this is right. It's going around. It's a thing. But we need some real usage data for those facilities so that we can make a decision that's fairly based.
Okay, but again, realize what your role is tonight. Your role is to apply the ordinance as it's presented. The fact that you may want to revise the ordinance because you believe that it might be incomplete data or you'd like to see a different data set used is a question for another day.
Well, let me restate. I want more information.
Okay, but is that information going to be for purposes of revising this ordinance for application down the way, or is this information to help you apply this ordinance to this particular property today? Okay, do you understand the difference?
I do understand the difference.
All right, Mr. Grabowski.
To help me decide if this ordinance is applicable as today, pieces of data that I would be interested in is, so we have 2585 total calls. We have 87 calls out of Cecilia alone, so we're just over 3% and just for them. But if I could get the numbers of out of 2585 that were applied to long-term care or that category of the elder care as we're talking about it, so that we could see what percent of calls were for them compared to the total, as well as then what is Cecilia compared to out of that category.
The overall allocation between categories?
Correct. So I forget, Summers probably has the correct terminology of how we classify it in the ordinance. I apologize for not having that, but how many calls are applicable to that? Okay, thank you.
I was going to say, don't you have a pie chart for that?
Yeah,
I do. I mean, it's
how many of the specific 2585 went to the care home category?
Well, and senior living. I would add.
Yes, and senior living, sorry. The ones with the elevated ESs.
I mean, can we get the data by facility also? I mean, if there's a facility that's more of a drain on our system, and they're categorized into this, if a facility could use Bell ambulance as opposed to, and I understand that data's not in here, but to a point, we could have facilities that use third-party services for their calls, but they're lumped into this care category, and it's inflating their fee for usage because they're not necessarily using Pewaukee, but they're lumped into that care facility. I think it would be helpful to see what this data is by these larger units in the in the in that category? Are we misappropriating on facilities, by specific facilities?
And Mr. Stark, do you have that information, or would you be able to supply that information within a relatively short amount of time, as in a few weeks?
I can speak broadly right now. In terms of the allocations, 32% of the calls that I looked at were for this senior living care home category.
So those two categories then?
Yeah.
37%.
32%.
32%, thank you.
Yes, it's roughly a quarter for single-family homes, a quarter for multifamily homes, 32% for this category, and then about the remaining 19% for commercial, industrial, and institutional.
And what additional information is the board looking for to aid in its decision? You are looking for more specific information in addition to that at this point?
I think I am interested in seeing the data set for the years prior to COVID so that we could compare them, like Bob was saying, so that we can see what the differences are between those.
Okay, but you understand, though, that what you have before you is an ordinance based upon this 3-year window, and that based on that 3-year window, a determination was made as to an assessment of this property. So that's what you have before you. Are you looking for that information because you'd like to perhaps revise this ordinance down the way, or because you believe that for some reason that it's not reasonable as it's applied today? You see the difference? Mm-hmm. Okay. I mean, I guess I understand what's been raised here this evening and why the questions are being presented, but there are questions that relate perhaps to two different issues. And the issue before you tonight is whether the fee that was assessed under the ordinance as it exists is reasonable for this particular property or not. And that's basically what this comes down to. So what information do you need to be able to answer that question is really, and if you feel you do, and you'd like Mr. Stark or the administrator to provide more information, or for that matter, Ms. Summers to provide more information from her client, that's fine, but we need to be very specific about what it is that we're asking for, and we can then go from there. So, Mr. Grabowski, you have your hand up?
Trustee Kreiser.
Okay, I'm sorry, Ms. Kreiser.
Thanks. So in light of what you said, so the fee being 4.75, so almost 5% higher than the basis, on a per unit basis, do we have the data that, I know we said 32% came from that segment, but on a per unit basis, is that 5% higher than a single family home and a multifamily home?
Okay, so just so we get the math right, if it's 4.75, it's 5 times the amount of one ESE, right?
Yes.
4.75 times that. So that's more than 5% more than one ESE, right?
Thank you.
Okay,
Yeah.
thank you.
That would be my question, to know about this specific conversation.
Mr. Stark, are you able to respond to that?
The ESC multipliers that were assigned were based on how many parcels we had or how many housing units we had for spreading out the allocated cost. So of the total cost that you had for fire and EMS, like I said, 32% was assigned to this category. I have to look up exactly how many housing units we had in that category, which is in my report. 498 units all told across that category. So in order to recover that proportional, in order to recover that allocated share of funds, we essentially did some quick arithmetic and said, okay, to get that amount of money from essentially 500 units, we need 4.75 times the single family home value.
To clarify, that 32% that you just mentioned, was that just senior living, or was that senior living and care home combined?
Combined.
And how does it break out for each?
I don't have that at hand, but I can pull it out of my files.
Okay.
The good news is that you already answered my question, because I was gonna ask how many units that was, so.
498.
498, got it.
Okay, so any other questions for Mr. Stark that we haven't already asked at this point? Okay, seeing none, then, Mr. Stark, anything else you want to add?
Nothing at this time.
All right, and I'll give you one more chance, Ms. Summers. Anything else that you'd like to say?
Nothing other than it sounds like there is still some open
Understood.
information that I think would be helpful, and also presumably if the information is provided to the board, you would also request a copy.
Understood.
Verify that information tomorrow in the records.
Okay, thank you, Ms. Summers. So at this point then, what I'm hearing is you want more information before you would make a decision. My recommendation to you at this point then is to make a motion to adjourn this hearing, to receive additional information, and then you need to articulate what that information is that you'd like to see. One of it was the breakdown between the care homes and the senior living facility. So what else do you want to know at this point? And would someone like to make a motion along the lines, or some other motion at this point?
I would like to know the relationship to the per unit, if we're going back for more information. I understand it's a percent of the total is how it was calculated, but my question would be the relationship to the other ones.
All right, do you understand her question? I'm not sure I do.
I could take a guess, but I would be a
So,
guess.
I mean, I
Prefer you not.
The answer, the fact that it was, if I'm quoting you correctly, and please if I'm not, because I was trying to write in a long time out of college, 2585 total calls. All right, 87 calls specifically for Cecilia at 55 units, if that's still what the CUG was approved for. So there are 1.58 calls per unit over those 3 years. Then outside of that, for the senior care and care home categories at 32%, you're dealing with full 827 calls at 490 units taken into that whole sub-segment there at 1.66 calls per unit over those 3 years then. If that's, so what I'm seeing here is that Cecilia was pretty spot on to the average percentage when we talk about senior care home, senior care, that subcategory, 1.6 and 1.58 and 1.66. So that might, I don't know if that's what you were looking for in terms of the breakdown of how we are. So when you factor that in, and this isn't me speaking as with my opinion or ruling, but when you factor that in, if we're saying the 4.75 is based upon your actual math of applying the added cost for the percent of calls, then it would lend me to believe that Cecilia was correct, had it correctly applied to them because they were right on the average of calls per senior care home. Again, not my ruling, not intended to sway anyone, but is that am I correct in the numbers and data you gave us to what I regurgitated?
If I'm trusting in your calculations,
Which please
then
don't,
I
I
would
was
agree with
terrible
you.
in math. I'm a bit, I was a
be more-
business major, so I did the bare minimum to get through calculus.
I'd be more comfortable if I went back to my source data. And
I think we
did a
all
full
would.
analysis.
So add that to your list of, if
Yes.
you want to make a list here, Mr. Stark, of information, add that to the list.
Please go ahead and strike my math from the record.
But you're looking for that consistency, in terms of this particular property as, the assessment that was made in general for that category. All right. Anyone else have other information that they would like to receive? All right, so we need to have a motion then at this point with regard to adjourning this hearing to receive that information. And yes, once Mr. Stark gets us that information, and I'd ask that you put that in a written format We'll provide a copy to Ms. Summers as well as all the members of the board, and then we'll reschedule the completion of this hearing once we have that information. What is a reasonable amount of time to provide that, Mr. Stark, at this point?
Can I have a week?
I'm asking what you think is reasonable, so as long as you don't tell me 2 months, I'm probably going to be pretty good with it, but I think the board would be pretty good with it, so.
I would request a week.
All right, thank you. So, does someone want to make a motion then to adjourn this hearing based on that?
I'll make a motion to adjourn this hearing based on us receiving additional information as requested.
Okay. Is there a second to that motion?
Second, Krasovich.
Okay, and all those in favor of that motion as presented signify by saying aye.
Aye.
Those opposed? Motion carried. Thank you, Mr. Stark. Thank you, Ms. Summers.
Thank you.
Okay, item 2 under new business is item B, hearing on an appeal of the 2023 fire EMS protection fee filed by Hawthorne Place LLC regarding real property located at 1105 Hawthorne Place and having tax ID number PWV 0902-996-007 and possible action therein. Again, Mark, I'll hand this over to you.
Okay, so this is now regarding 1105 Hawthorne Place as indicated. And council, I'll let you go ahead and make your comments, but I think we're probably headed down the same path regarding the information. No. Okay, folks, let's just hang on here for a second. Are you going to be looking for the same kind of information or requesting that the board adjourn your hearing until that additional information is received?
Well, I have some information just to share with the board. I'd ask that maybe we revisit that at the end of my presentation.
All right, go ahead.
I'm gonna have to raise this mic much higher.
How about that?
I think we need to get a new one.
If you can't hear me, I can just speak loudly as well. First of all, thank you.
We're trying to record it, so please make sure you use the microphone. Thank you.
All right,
As best you can.
all right.
Thank you.
So my name is Eric Hatchell. I'm an attorney at the law firm of Foley and Lardner. I represent Hawthorne Place LLC. And just listening to the dialogue the last hour and all the questions, I was just reminded, like, budgeting municipal government is really hard. So there's so much limitations put on you in an era of rising cost and inflation. It's really difficult to do. And so thank you, first of all. I know it means a lot to everybody sitting in this room, a lot of residents from Hawthorne Place, that you're taking the time to carefully think about the implication of what happened here that may have not been realized by this board when it decided to categorize these properties the way that they were. I agree with Attorney Blum about, what's the purpose of today's hearing, right? We're not here to talk about policy and revisiting it, but that's something this board can revisit in the future. And given the comments and the questions that you've raised, I'd encourage you maybe to think about that in the future. You guys had a lot of questions about data. I have some data. I have some information. If it's okay, and if I could approach, I'd like to share that with
Sure, do you have copies for everyone? Or?
I brought like 7 or 8.
That should get at least to the
get a couple
board
extra.
members. Yeah, and then one for the record to the clerk, Ms. Smith, there in the, to categorize the color of your shirt or your blouse, but I'm not going to do that, so I'll invariably be wrong.
We'll just let that get passed out and then give everybody a second.
Do you have enough, though? Why don't you give me sure that all the trustees have
Okay. There's 3, there's 4.
So you keep one and then 3 for the 3 of you down there. Okay.
We don't have any for down there.
Well,
I'll share with
I can take a picture of it.
trustees.
I'll look at it on my phone. It's fine.
All right, so I just broke the cardinal rule. I just gave you something. I don't want to talk about it quite yet.
So don't focus on it until he tells you to.
But we'll get to this in a second. I promise. Because I just want to make a couple of things clear. I agree with everything Attorney Summers said, and I'm not going to repeat all of those. We think this is an unlawful tax. We don't think this is lawful, but I'm not going to stand here and try to convince you I'm right on that. That's a fight for another day. I also agree about what the purpose of this hearing is that the ordinance gives you discretion to determine what is fair and reasonable. So again, we think that this ordinance and fire EMS fee needs to be unwound. We don't think it's consistent with the requirements of Wisconsin law. But again, that's a fight for another day. What I'm asking this board to do today is to consider whether Hawthorne's Place categorization in the elevated 4.75 ESE charge is fair and reasonable given the makeup of Hawthorne Place, which is very different than the property we just heard, and is very different than the other assisted living facilities located in the village. I have Mike Heisey here from one of the owners of the property. He obviously knows a lot more about this property than me. I'm not going to call him as a witness. That's not the intention of our presentation today. But to the extent there are questions about the number of units or the type of services, which there aren't many. I heard there was a social director today, though. I found that out. So, but there are questions, and Mike will answer that. So let me just talk a little bit about Hawthorne Place, but why it's different, and then we'll get back to this chart that I gave you. Okay. So Hawthorne Place is a 55 and older independent living community. So it has 104 units, okay? And while its focus is 55 and older, it's not exclusively limited to that age group. And approximately 15 to 20% of the overall residents are under the age of 55. Contrary to the property we just heard about, there is no assisted living provided. There's no care of anything. I mean, what this is are people who are 55 who just happen to live in a close community next to each other.
I'm sorry, just make sure I heard that. So there's no care provided then whatsoever, Mr.
Correct.
Cashel?
This is not an assisted living facility. This isn't a property where you start independent and then increase to other types of care that you need. This is simply a facility of people generally over the age of 55 that live close to each other.
Just Attorney Blum. Go ahead. Because just for clarification, independent living can provide services. You know, how remedial they are, or what have you. So, to be clear, to not blur that line at all, where you say, "Well, this is just independent living, people living together." There isn't even there's not even an option for it. There's not a phone number to call if you fall down or need groceries or anything like that. This is strictly apartment living.
Mike, could you go ahead and confirm that, please?
Yeah, it's strictly independent living, and it's zone multifamily, which is different than the other senior living facilities. We are zoned no different than any other apartment. And we do not provide any assisted living.
So no ADL assistance that was discussed earlier? Okay.
Nothing provided on like a la carte that if you do use it at some point, you get charged for it. There's not even an opportunity.
And sorry, it's zone multifamily, so it's just a coincidence that it's become a 55-plus facility?
No, you can designate any apartment as a 55 and older community.
So it's designated as 55-plus?
And it's zone multifamily apartments, no different than any other apartment.
Gotcha. I just wasn't clear if it was actually designated for the 55-plus age group or not, given that people
And that's an allowable category that you can market it and group it that way. My general understanding is that you need one person in the residence, 55 or older, and that there's, but then you can have other people less than that. So again, in this property, it, fluctuates, but it's about 15 to 20% of people that live at Hawthorne Place are under the age of 55. So I think, given the questions that this board was asking before, I think that's really important facts of when you think about how Hawthorne Place was put in the same elevated category as all the other assisted living facilities that obviously need a lot more care, need a lot more service calls for fire and EMS. So now let's go to the chart that I handed to you. So after I got involved with Mike, we went to the City of Pewaukee Fire Department to ask for some more data. Now, again, this doesn't give you everything you were asking for. It doesn't have the breakdown of types of calls, if there was a misdial, but it does give us a good snapshot of the total calls going back all the way to 2015. So it gives us a good snapshot of, current and of course pre-COVID. And I'd ask you to kind of look at the numbers compared to Hawthorne, only 12 EMS calls back in 2015. 31 and 16, 19 and 17, 22 and 18. So it's a substantially less than other facilities. I understand the Kirkland Court and the Quinion Drive are related facilities. As you can see, they offer higher levels of care at those facilities, and the calls are much more higher. So again, your discretion here under the statute, is it fair and reasonable to treat a facility that doesn't offer any sort of care, that is simply residents of a certain age group living close together, the same as all these other facilities? I'd say that it's not. So just a little bit more data. And by the way, the consequence of this is striking. It's an additional tax of a nearly $120,000 to Hawthorne Place, given the heightened category of the 4.75 ESE. Just breaking down the data a little bit more, this is focused from 20 to 22. We heard this number repeated earlier. There was a total of 2,330 fire and EMS calls within the village during the 20 and 22 time period. Only 3%, approximately 3%, if you take Hawthorne's numbers, it was 3% of the total calls. Yet if you look at the charge to Hawthorne Place itself is responsible for 7% of the fire and EMS budget based on the tax bill that they were given. So is that fair and reasonable? No. Also, just another fact I looked at, we went and pulled recent census data for the village. I have 2022 data here. The population was about 8,200, a little bit more. And the 55 and older population was about 3,500. So in the village of Pewaukee, 42.5% of the population is 55 and older. And of course, they live in various places. They live in single-family homes. They live in facilities like Hawthorne Place. They live in apartments. But why treat them differently? Simply because these people want to live by each other, and they're not asking for any sort of elevated care, that they are going to be penalized and have to be responsible for a disproportionate amount of the fire and EMS budget. It's just not fair and reasonable to treat them any different than anybody else who's 55 and older in the village. So again, Attorney Summers mentioned kind of the statutory provision that she mentioned before under 660627, which allows the village to impose special charges for current services. 3% versus 7%, kind of repeating myself here, but you can see the issue that my clients have, the significant tax, and we'd ask you to reconsider and to categorize them as the multifamily 1.0 ESE instead of the elevated 4.75. So unless there's any other questions, that will conclude my presentation.
Thank you. Any questions from Mr. Hatchell at this point? Yes, Mr. Kowalski.
This would probably actually be more of a question for Mr. Heisey as the owner. So, when we're looking at it, and obviously it was categorized as senior care home, 55 and over generally falls into that. If you're not providing any services, what is the benefit of marketing this as a 55 and over community, and how strict do you adhere to that?
Well, back in the late, what happened?
And I'm sorry, to clarify my stance, I'm saying, is there any monetary, state-driven reason to market this as a 55?
No, it's just that you can now market it to elderly residents, 55 and older, that are empty nesters, that don't have children, that don't want to live in apartments with families. And that's the one major benefit of 55 and older community.
And then the second part of that question was, how strictly is that adhered to? I mentioned about 15 to 20%. I know I've heard of other communities that anyone under 55 can only be there for a max of X amount of weeks per year type thing.
do you allow families, or let's say I wanted to rent there as an opening, would I be allowed? Under,
You have children, but if you are under, we're allowed, 55 and over is a designation, that's actually a legal designation by HUD. And what it does, it allows you to have residents, 20% of your residents can be under 55 and over.
okay, thank you.
Any other questions for Mr. Hatchell or Mr. Heisey? Okay, thank you. Mr. Gussie, Mr. Stark, anything that you'd like to offer in support of the assessment that was made for this property?
And when we looked at the property, it did fit within the code definition of senior living, which includes residential care facilities, and senior living residential developments, which are marketed and are limited to residents 55 years of age and older. We did find information on the internet, apartments.com, and their own website, which indicates that it is oriented to 55 and over. There was also signage that was seen placed on their property, which states adult living 55 years and over. So we felt comfortable that the property fit within that category, as stated to this evening too by Mr. Heisey. There are 104 units on the property. Again, looking at the 4.75 ESEs, that calculated out to 494 ESEs. And those numbers were not contested as part of the appeal. So that's the information from a categorization standpoint, looking at the definition of the ordinance and where this property would fit in within the ordinance.
Any questions for Mr. Gussie? Okay, thank you. Mr. Stark, do you have anything that you'd like to add on this?
Nothing that hasn't already been stated.
Okay, any questions for Mr. Stark with regard to this particular property?
I don't have one for Mr. Stark. I should have asked when the attorney was up, but I do have a question about what he handed out. Is that okay?
Sure.
Okay. In your handout here, I'm looking at the amount of calls. Is that what this represents? For just EMS?
Correct.
I only see 2 years where actually Cecilia Drive, which does have assisted living, is under the number of calls that Hawthorne received. Is there a reason for that?
People.
That's maybe based on the size of the facility, but go ahead.
Okay, just asking.
Yeah, and
You received the data from the city fire department, so I don't know that you have more, I guess, you can't drill down into the specifics of those particular properties. Is that fair to say?
exactly right.
All right, thank you.
Foundational knowledge of this information. There's 2 Cecilia Drives. It's going to matter on how they categorize the numbers, how many total people. I was just presenting this information because there's a lot of questions the last hearing.
Understood.
More data, and I wanted to provide what I got to the board.
Thank you.
I guess with that being said, I again had the same question, is why didn't you do fire calls and any other calls too?
So this was the data that they gave us.
Oh, okay.
That was EMS only. Obviously, fire calls would be significantly less. So this was, again, the data from Baker's Hill, I'm not questioning that, right? This was just some supplemental data that provided some earlier. I'm not reporting that this is all the data. I'm just saying this is some additional data I thought would be relevant to the board's consideration.
Other questions at this point? Okay, then hearing none, we'll close, is there anything else, Mr. Hatchell?
No, thank you.
All right, thank you. So we'll close this at this point. We're looking for same kind of decision matrix, either to adjourn this if you want more information. Second, if you want to approve it as it was assessed. Or third, you want to revise it because you don't believe what the assessment that has been made is reasonable as per 93-105 of the Village Code.
I'll make a motion to reclassify Hawthorne Place as a multifamily unit
Okay. Is there a second to that motion?
I'll second it.
Do we have discussion before seconding?
Let's get the motion on the table, and then you can discuss the motion at that point. So I heard a second from Ms. Belt, and at this point, we'll throw it open for discussion. Mr. Grabowski.
I am inclined to go the route that Trustee Gergen and Trustee Belt had motioned, because I do believe that it doesn't fall under the category of elder care with the lack of services and such. The part that I just struggle with, and it's not necessarily a struggle, it's a question more so, is the 55 and older designation and the number of calls and the average number of calls that very much mimics some of the other facilities. However, I'm more inclined to go the multifamily route because of the lack of service. Sorry, apologize everyone on the recording too. Of the lack of services. So I don't disagree that this should not be categorized as, or I'm sorry, I disagree that this should be categorized as a senior care or elder care, because that's not the case. I don't know if I feel there should be a separate category, because there are other 55 and older apartment complexes within the village. This isn't the only one. Because truthfully, I don't think I could sell my house and limit it to 55 and over. There are exclusions here. So it's based, if you want to go the route of it's not available for everyone. So therefore, it is not the same as a multifamily through and through. And like I said, the data here provided by their own attorney shows that. That's what I will say on that, but I agree, it should not be going the way that it's currently set. And I'm fully in support of that, just don't know to what final extent.
So would that be, that would be more for us to talk about going forward and calculating for future years?
This is solely regarding this property under this ordinance
Right.
tonight.
So we can have those discussions of creating separate categories going forward into future
Then I am
years.
in agreement then.
So one question, though, Trustee Gergen, the appellant asked for then a refund if you chose to adjust the amount of their ESEs. Is part of your motion to grant such a refund, or is that something you want included in your motion or not? Just to make sure the record's clear.
So that the refund, so that they would be charged the difference between the 1 ESE to the 4.75. So like a refund of 3.75 ESE.
Well, I guess we could let the administrator calculate that out if he believes the motion provides sufficient information.
If the motion includes designation and a refund be granted to get it to the equivalent as a multifamily, then I think that's correct.
All right,
Yes.
so would you like that as part of your motion?
I would like that part of my motion.
And Ms. Belt, do you agree that that should be part of the motion that you seconded?
Yes.
All right, is there any further discussion regarding this particular motion?
I would like to say one thing.
Sure.
The difference with Hawthorne and the number of calls that they have is that Hawthorne has almost twice as many units. They have 104 units where.
I went average calls per unit.
Okay.
So I didn't just take total, I did calls per unit, so.
Okay.
Further, Mr. Rhodey.
Yeah, I just question how we can make a quick decision tonight unless we get a look at all the information that we're requesting for both properties.
Okay. Other comments?
I have a question about how that withholds with the definition stated as it is in the ordinance for senior living, which is the marketed and nor limited to residents 55 years of age or older.
Right. The ordinance language.
The ordinance language does include them in the senior living for everything that I'm understanding.
So you're referring to section 93.101 sub H yes, H as to the designation or definition for senior living.
Correct.
And your comment is then,
That does, how are we withholding that, or renacting it based on that definition?
so one way it would seem to me that you could look at it is that, in fact, that this property does fit that definition, which is why staff categorized it as it is. But the argument that's being made is that determination fair and reasonable with regard to this property, which I think is where Trustee Gergen and Trustee Belt are going. At least that's what I'm hearing.
Yes.
All right. Does that answer your question?
Yeah, thank you.
Other questions regarding the pending motion?
I guess for staff here, if we were to change this to categorize them as multifamily, does that change anything considering it's a CUG for 55 and plus community, which is categorized in our ordinances as senior living?
No, I can answer that question. If the CUG, the only way that could be amended is to go through the process under your ordinance, which would involve a review by the Plan Commission, a public hearing, and then action by this board to revise the CUG. So it's a long way of saying no, unless you go through that whole process. That doesn't change that this is a 55 plus community under your zoning code.
Okay, thank you.
This is only for purposes of your fire and EMS ordinance.
That was my question.
Other comments or questions regarding the pending motion?
Just if I could make one more comment.
Sure.
Again, just stating the fact that asking for more information before we making a decision is not a yes or no to this decision. It's getting the information and making sure we understand everything that we're deciding on prior to making that decision.
So what additional information would you like to see on this
Same thing that we're getting for Cecilia Place.
Other comments regarding this pending motion?
Well, I just have a question. First off, I'd like a statement. I agree with Trustee Rhodey that making a snap decision without getting all the information that we are requesting from the other one is also necessary, I believe, for this board to make a good and fair decision. Also, we don't have an idea of what the cost to the village would be to refund the amount that we've already charged or has been paid. I think that's necessary that the board should have that information before we do that. And also, can it be reclassified, or can there be another classification made for just a 55 and older at a different rate? Is that something that could be discussed?
That would need to be by way of a revision to your existing ordinance, and
Right.
that, what we're talking about is the ordinance as it exists.
As it exists right
applied
now,
to this
right.
property. And whether you want to change that in the future is a decision for another day. So I will say then, I guess, if in fact there is a desire on the board's part to get additional information, at least some of you, a motion to table this is possible as well, pending the receipt of that information. However, the existing motion would be the one that would be considered out of the blocks at the time that you take it off the table. In other words, that's still what's in play, and you'd be starting from that position. Again, assuming anybody wants to make a motion to table this to receive that additional information.
I agree with Trustee Rhodey in the fact that asking for more information is not necessarily a yes or no. In the case of Cecilia, I fully support the fact that more information is needed in that one. Since I would be requesting more information for a ordinance revision is where my request for more information would come in terms of what we have in front of us today, in applying it. So I don't think you're off base at all for your request there. I feel, my personal feeling is that we can make an adjustment this evening. This is, again, speaking for myself.
in this one instance, based upon the information that is provided, and from my aspect, it's largely based upon the services rendered in terms of how it fits into the classifications of the categories. Now, what that means on an amended ordinance going forward, completely different, and yes, more information would be needed by myself in order to cross that bridge. But in regards to tonight, I feel like the motion that's on the table, personally, I feel is reasonable, but I don't think you're out of line saying that more information is not, or is needed.
Okay, a motion's been made and seconded at this point. Are there any other discussions or any other motions to be made at this point? Otherwise, we'll call for a vote.
Could I table it?
Now we have to do the motion to start.
Okay, if you want to make a motion to table, you can do, someone can do that at this point. I'd suggest the chair not do that, but if
Okay, I
that's-
won't then.
I'd like to make a motion to table until more information is provided.
Be specific about what it is that you want for additional
More
information.
similar to the information on data prior 3 years versus the 3 years that were compared. Also want the similar information to what we are providing for Cecilia Place.
All right. So a motion to table has been made. Is there a second to that as presented? Okay, hearing none, then the motion fails for a lack of second. And the motion to approve the appeal as presented and have a refund in accordance with that is before you. All in favor signify by saying aye.
Aye.
Those opposed?
Nay?
Nay.
Okay, Madam Clerk, would you do a roll call vote, please?
Trustee Kreiser?
Nay.
Trustee Grabowski?
Aye.
Trustee Gergen?
Aye.
Trustee Rhodey?
No.
Trustee Belt? Aye. Trustee Krasovich?
Aye.
President Knutson?
Nay.
The motion is passed 4-3, and that concludes this particular appeal. Is there, hearing there's nothing further to come before the board as to the special meeting, we're looking for a motion to adjourn.
I'll make a motion to adjourn.
Second, Krasovich.
All in favor signify by saying aye.
Aye.
Those opposed, motion carried. We'll take a 5-minute recess before we begin with the regular village board meeting to follow.
You can stay. You can stay.
Hated this meeting. This is ridiculous. This meeting, I didn't like this at all. It was just, you were very good at it. I had so much questions that I just knew I could ask.
Jane, understand why it was that, you have to understand their last.
Oh, I understand.
And the fact that we might have some buyer's remorses to the ordinance at this stage, you know, that's a question for another day, but that's really that.
Oh, yeah, I understand. And that's why I'm glad you took it over, because I would have let a lot more go through.